Hey everyone, Harry here to talk about the Manhattan DA's office blistering response to Jim Jordan and his letter from the Oversight Committee, which he chairs, to Alvin Bragg, seeking to basically officiously intermeddle in the pending, still investigation, not even a case yet, against Donald Trump. So the the order for information and to show up from Jordan is really extraordinary, right? It's already improper, but something they got used to doing in the Trump years to try to meddle and get non-public information about a pending investigation if it's federal. That's the sort of thing that there was way too much, and anything over zero is too much sharing of information and demands from Congress, who, among other things, tend to leak immediately, and there are very good reasons to keep information confidential, including protection of defendants. But it's just so axiomatic that when you're doing an investigation, it's not for the general public. You can't develop your investigation that way. It totally prejudices your ability to deal with witnesses and the like. And as I say, it can be deeply unfair to defendants. So this is just an elementary principle. And Jim Jordan, who ironically the MAGA crowd says they're in favor of local power and against overweening federal power, deep swamp bureaucracy, is trying to nevertheless just go in like a bull in a china shop. So a 5-page meticulous letter from the counsel in Bragg's office. It starts with the very basic point of, you have no business whatsoever in a pending law enforcement investigation. The Supreme Court has said repeatedly, Congress is not a law enforcement agency. Congress is not an executive branch. And that would be the case, again, for a federal setting, but all the more so in a state prosecution. And that, in fact, leads to the next general theme in the letter, which is, this is a 10th Amendment problem. The 10th Amendment is the one that, often conservative judges love to invoke about the federal governments not being able to just commandeer or throw themselves in the middle of state sovereignty. And there's nothing more integral to state sovereignty than the enforcement of the criminal law. So even apart from the very basic inappropriateness of Congress making itself out to be some kind of supervisor of law enforcement and the executive branch, it's double, quadruple that when you're talking about a local law enforcement agency like the Manhattan DA. Now, Jordan's letter, of course, says with no evidence that this is a political prosecution. Let me stop there for a second, because we hear from a lot of folks, look, that the politics and the law are unavoidably intermingled. And look, in a way they are. You're talking about prosecuting a former president of the United States. You're talking about somebody from the other parties doing it. But while that's a sobering possibility that you want to think about hard, the answer cannot be that because there are political ramifications, you may not bring a prosecution, right? That's equivalent to the death knell of the rule of law where political officials are concerned. So we're going to continue to sort of debate this as a country, but it seems to me the watchword should be, for starters, that if there are equivalent cases that you would bring against anyone, it would not only be appropriate to bring them against a political official from the other side, it would be arguably inappropriate not to bring them. And I only say arguably because where a former president is concerned, as always with Trump, we have certain unprecedented contexts. You can imagine at least thinking about it more. But the short answer for Bragg is to this political purpose charge is no, we do this in similar situations all the time. And in fact, they do. There's a very good piece out in Law and Security by Ryan Goodman, and a short version of that in the New York Times by Goodman and Andrew Weissman, that just go through many cases that are similarly situated where the local authorities have in New York have pursued it, and it just show that all this pontification that the Republicans have been doing about this would never be done with anyone else is just simply wrong. Nobody checked their facts. Okay, so for the political purpose, there's also an answer under the law. It's a really important answer, and it's a completely established answer. If you can show there's a political prosecution being brought, that's a constitutional violation, and you bring that claim in the courts. That's a legal infirmity with a legal case, and the right place for that. And this is maybe the third big chunk of the themes in the Manhattan DA's letter. The place for that. This is not political, they assert, and they, I think, do it with good reason and say it's just not enough, that it's a political official on the other side. But there's a time and place, and that's true for all of these things. You're going to see the Republicans looking to just basically, muck things up where they really truly have no federal legislators, where they really truly have no business whatsoever, nor do they care. It's just a way of being in this sort of political fray and trying to score points for, their broader partisan battles involving the parties, the 2024 election, and the like. Okay, and then finally, to try to have a read to stand on, Jordan's letter talks about the federal funding that the Manhattan DA's office receives. First of all, there ain't much of it. In general, local prosecutors' offices are funded by local tax dollars. It's true there is in a big office like Manhattan DA, there would be certain programs that federal funds might contribute to. But the last major point in the DA's letter is what that has to do with a specific prosecution or investigation against anybody is a complete mystery. It basically is utterly unrelated and doesn't begin to provide some kind of justification for the intermeddling, to the extent it's a sort of latent challenge to withdraw the money for, which would be really improper and very politicized on the House's part. They say at the very end, they sort of give I don't know if it's even an olive branch, because it's such a scathing letter. It more kind of underscores how out of bounds the Jordan letter is. But they say, we will put together a census of the federal funds we receive, which is something that they were asking for in the letter. Very good. Goodbye. So the fight's not over. I think you're going to see these guys, just for the sort of theater of it, try to force Bragg to the carpet, etc. But he's going to go to court. Could be state, could be federal court, but either way, he should prevail. They have just no business calling him to the carpet, and a lot of reason that they shouldn't be, because it's interfering with really the heart of sovereignty and sovereign functions, the enforcement of the criminal law in New York. All right, so a very hard-hitting response back to Jordan and the efforts of... Jordan's done a lot of this since taking helm in the Oversight Committee, and they've pretty much all been, whiffs or foul tips. This should be another one. It would be an outrage for a court to order a local prosecutor to somehow, show up and have, get a tongue wagging from the Congress, much less to provide any information, which is what they're wanting to do, in order, of course, to leak it, exploit it, leverage, etc. Exactly what a criminal prosecution is supposed to avoid. All right, so there you have it. A strong pushback from Bragg. The battle's probably not over, but man, are they in the right legally, morally, practically, etc. And it's a very well done letter. We'll see what Jordan's next move will be if he tries to subpoena him, or there's a court battle ensues. And Bragg ought to prevail, and he's certainly ready to take this fight. Okay, so more to come on this probably. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.